The Attorney General, Godfred Yeboah-Dame, has raised concerns regarding comments made by certain individuals in high positions that could potentially impact the ongoing criminal trial of Asin North MP-elect James Gyakye Quayson. Mr. Quayson is currently facing charges of perjury and deceiving a public official after allegedly denying allegiance to any country other than Ghana during the 2020 elections. The decision to proceed with the trial has faced criticism from some quarters, with claims of intimidation targeting the NDC legislator who emerged victorious in the recent by-election held on June 27. Quayson's legal team has already filed an appeal seeking to overturn the High Court's ruling to hear the case on a daily basis. Amidst these developments, there's a growing demand for the state to discontinue the trial, with Dormaahene Osiadia Adjumabedi II, a chief who also serves as a High Court judge, urging the Attorney General to enter a nolle prosequa, effectively dropping the charges. However, Godfred Yeboah-Dame, in a response, expressed concern over the potential impact of such comments on the fair adjudication of the case.
I'm not going to comment on it right now. I'll come up with a proper statement on the matter, and it will be in respect of all comments generally which have the tendency to subvert the administration of justice. I think that is very unhealthy for our democratic dispensation, and therefore we must not countenance it. And I find all manner of, with all respect, lawyers, some of them in considerable standing at the bar, making all kinds of comments affecting even the hearing of cases that are going on. Indeed, we are all equal before the law.
Meanwhile, the Court of Appeal has overturned a decision by the new trial judge in the case involving Dr. Stephen Opuni, the former CEO of the Ghana Cocoa Board. The trial judge, Justice Anoche Jima, had ruled to start the proceedings afresh due to various defense applications seeking the recusal of Justice Honyenuga based on allegations of bias. Disagreeing with the decision, Attorney General Godfred Yeboah-Dame filed an appeal, arguing that it amounted to a miscarriage of justice. The Court of Appeal, after considering the appeal, concluded that the trial judge had erred by misdirecting himself in ordering a fresh trial. Attorney General Godfred Dame expressed satisfaction with the appellate court's decision during a media interview following the proceedings.
It is actually not unconventional for criminal proceedings to be adopted in a trial, and so it cannot be correct that when it comes to civil matters there's provision for adoption of evidence, and in criminal matters there's no such provision. Indeed, the true position of the law is that it is actually up to the trial judge to make that determination, and the trial judge makes that determination based on factors that it considers necessary. And if the parties are aggrieved by the exercise of that discretion, the parties are entitled to lodge an appeal, which we did. And we felt that the matters that were relied upon by the trial judge were, with all respect to him, quite irrelevant, and therefore the proper thing to do, which is actually the most progressive step in the circumstances, was for the evidence to be adopted and for us to move on. And I think that it is actually a little bit backward, with all respect, for a trial which has advanced to this stage, for another to be made that we should start de novo. It will amount to giving the evidence twice. It will amount to giving any of the parties to the matter a second bite at the cherry.